Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And today we're going to begin discussion regarding record retention requirements. I know that sounds really exciting, but let me tell you, the Department of Licensing is auditing for this issue right now. So this is really an important issue affecting both firm management and brokers. Brokers, you are responsible for delivery of documents to the firm so that the firm can store them in accordance with the DOL's requirements. So it's important that everybody understand what's going to be said in this two-part mini video series. You will find all of the same information in an article released in the RE Magazine Winter Edition, just mailed out in January of 2019. Okay, every firm is required to maintain on every transaction, as that term is defined by the Department of Licensing, a transaction file. Transaction files must be maintained for a minimum of 3 years from the date of closing or the date that activity on in the file ceased. The 3-year minimum is the Department of Licensing requirement. You should talk to your own firm's legal counsel about how long your firm should retain files. Most lawyers are likely to tell you that 3 years is not long enough. The statute of limitations on a misrepresentation or negligence claim is 3 years. The statute of limitations on a written contract claim is 6 years. Neither of those statutes begins to run until the injured party or the allegedly injured party has a reasonable basis for discovering the injury. So it is entirely possible that a lawsuit gets filed years and years after closing. Under the theory that your transaction folder is going to do more to protect you or defend you than to hurt you, which I think is true in most cases, then you want to still have your transaction folder when a lawsuit or even a DOL complaint is filed and DOL investigates the complaint. Let's talk a little bit about the definition of transaction, because I remember I told you that you have to retain a transaction file on all transactions as that term is defined by the Department of Licensing. And let me start out by telling you that in recent history, the Department of Licensing changed its definition of transaction based on a decision issued by the administrative law judge that hears complaints coming out of the Department of Licensing. So the Department of Licensing believes its hands were tied, and the definition of transaction is one that it has to impose on brokers and firms. And here's the definition. The definition of transaction includes not only closed transactions, but offers that were never accepted and failed transactions, anytime a BPO was written or a letter of intent was written. 5 categories: closed transactions, failed transactions, offers that were submitted but never accepted, BPOs, and letters of intent. Now understand that a letter of intent may evolve into a closed transaction, or it may evolve into a failed transaction. You don't have to have a separate transaction folder for the letter of intent and then another one for the transaction itself. The letter of intent can be in a transaction folder that evolves to include all of the documents for a failed transaction or a closed transaction. Same is true of a BPO. Maybe a BPO is written in support of trying to obtain the listing. If you don't get the listing, then the BPO may be the only thing in the transaction folder. If you get the listing, the BPO may be the first thing in a transaction that evolves then to a listing and then to a closed transaction. So I think I might have actually left something out of the list. Closed transactions, failed transactions, offers that were submitted, BPOs, letters of intent, and you've got to have a transaction folder for all of your listings. If the listing never evolves to a closed transaction, then you still got to have a file on that listing. Okay. In the next video series, we're going to talk about what has to be in that transaction folder. for the rest of this video, I want to make sure that firms are clear about their requirements. Firms, you have to maintain that transaction folder for as long as your lawyer tells you you need to maintain that transaction. Minimum of 3 years for the DOL standards. The other requirement similarly associated with transaction folders is the maintenance of a transaction log. Firms, you have to have a mechanism set up where your brokers, you or your brokers, your office manager, somebody makes an entry on your firm's transaction log every time a brokerage service is delivered. So maybe that brokerage service is a listing. Maybe it is the purchase offer. Maybe it is a letter of intent. Maybe it is the delivery of a broker's price opinion. Every time you have the delivery of a real estate brokerage service that would originate the creation of a transaction folder, you have to have an entry on your transaction log. So and on your transaction log, you have to identify the property address, the party names, the brokerage service that's delivered, the broker name who delivered the real estate brokerage service, and if that broker has been licensed for less than 2 years, the name of the managing broker responsible for supervising that broker. So for example, you might have a broker who's gone out and made a listing presentation and provided a BPO. That BPO would be identified on your transaction log by property address, party names, BPO, broker name, and if they've been licensed less than 2 years, their managing broker. And then you'd have another entry, completely different transaction for the writing of a purchase and sale agreement, and then maybe another writing of a purchase and sale agreement, et cetera, et cetera. And you have this transaction log. Every entry on that transaction log should tie to a transaction folder in the firm, so that when the DOL auditor walks into the firm, the DOL auditor will ask for a copy of the transaction log, be able to look at the transaction log and go, this one, I want to see this transaction folder. And they'll identify the transaction folder by the property address and the party names. You are expected, DB, to go over to your file, whether it's electronic or manual, pluck out a file and put that in front of the DOL auditor. If you have a transaction where you as a designated broker are a dual agent because one of your brokers represents the buyer and one of your brokers represents the seller, question is, must you as a designated broker have two separate files, or could you have two separate files for that transaction? The answer is yes, you could have two separate transaction files. You could have a seller side, you could have a buyer side. And more importantly, designated broker, if your transaction folders are not kept in a confidential and secure manner so that both brokers can't both access that file, then you have to keep them separate. Maybe I said that backwards. If both brokers can access your transaction folders, then you have to keep them separate and allow access for the buyer's broker only to the buyer's transaction folder, for the seller's broker only to the listing file. In other words, you have to have a way of securing the confidential information of the parties that you represent. Finally, I want to cover in this video where and how you store your transaction files. Most firms today store their files electronically. And if the files are stored electronically, then all that you have to be able to do, designate a broker, when the DOL auditor walks in your office, is you have to be able to retrieve that file instantly in a format that allows the records to be stored as they were stored without manipulation. So the files can be stored electronically as long as you can access them when the DOL auditor walks in. If you store your files manually, then for a year after either closing or activity has ceased in the file, you have to keep those records on site so that when the DOL auditor walks in, you can literally pick up the file and hand it to the auditor. After activity has ceased for a year, then you can store them off-site so long as all of your off-site storage is in one single location somewhere in the state of Washington, so that those records can be retrieved back to the office for an auditor to look at in a reasonable amount of time. Again, all of this information is set forth in writing and maybe different examples given in the article in the RE magazine, the winter edition 2019. If you have questions on anything in that article or anything in this video, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.